we're getting close. We're right at 10 o'clock and we love to start on time. And we know attorneys bill by the hour and the minute. So, so we don't want to take up too much time. We are very, very excited and we're lucky to have a relationship with Saad. He has Paradise Coast title in Naples. So he does all different counties and I'm sure he'll tell you a little bit about it, but he is like the expert in the neighbor market and contracts. And he also really understands our topic today about homesteading, and we're trying to give you some tools that you'll have as you move forward into the season. And we have really unusual deals this year, so we want to arm you up with some more information. So without further ado, Sam, it's yours.
Oh, thank you, JJ. Yes, this is definitely the year of unusual deals. All types of interesting stuff going on. So I'm pretty good with technology, but give me a second. I'm going to share my screen, and today we're going to talk about Homestead, what the realtor needs to know. And now I'm an attorney, so we're going to start off with a disclaimer. I'm going to be giving you some advice and discussing the homestead laws, but if you have any specific questions, then just give me a call separately and we'll go over your specific situation. Before I get into the presentation, a little bit about our offices. We were founded in 2007. We have offices Naples, Marco, Estero, and Cape Coral. I got to put that on here. I'm going to fix that. I do handle real estate and business law. We're dedicated to helping small business owners, entrepreneurs, buyers, sellers, and property managers mostly. We have a full service litigation department. So if you get into deposit disputes or evictions, or you come across a foreclosure issue, we can handle all of those as well. A little bit about me. I've been an attorney since 2003, and I specialize in real estate law. I serve on the committees that write the NABOR contract and the FAR contracts, so I'm pretty familiar, you might say intimately familiar with them, especially for those of you that use the FAR. I'm actually going to be putting out a presentation, putting it together now, because it's changing significantly in November, and they're going to be fixing up the finance contingency, some of the inspections, and some other things. I am a recovering politician, so you'll have to excuse any jokes. We're making title great again, that sort of thing. All right, let's dive right into homestead, real property, ad valorem property taxes. So before I get into this, let me say we're going to talk. There are 3 homestead protections in the Constitution, and then there's the federal law related to capital gains tax. We're going to touch on the 3 homestead protections and very briefly on the capital gains protection. And ad valorem property tax savings for homesteaders is just the first of the 3 that we're talking about. I should also do a second disclaimer. This is actually the first. You guys are my guinea pigs for my new presentation on homestead. So if I say anything that seems strange or you have any questions, you should immediately stop me and shout them out. We can talk about it, make sure I'm saying what you understand. But we're going to start with tax savings for homesteaders, and let's talk a little bit about the basic property tax system. So, it's an annual, reoccurring annual thing to assess and notify and tax and collect the taxes on each property in the county. That's every piece of real property, no matter how big or small, in the county every year. On January 1, the county assessor assesses the value of the property. Now, obviously, they can't come around on January 1 and assess, millions of properties across the state of Florida every year. So they have systems in place, and it's as of January 1. They go throughout the beginning of the year. They assess the values. They look at sales every time they come in. They look at changes that are for no value and discard those. They look at comps, and they give you they come up with a number, and then they send out a trim notice, the truth in millage trim notice, in August, and that tells you what your valuations would be based on the various scenarios for the state, for the county and local government tax rates. And if you are unfamiliar with what a trim notice looks like, you can go to leepa.org and pull up your property and look at your trim notice, or you may have gotten it in the mail. Any property, it's on every property and it's all public record. Once the trim notice goes out, you get an opportunity to object to your valuation, and you can go before the VAB, the Value Adjustment Board, the VAB, and dispute your value. That doesn't usually result in much of a change for most people, because especially, and I can speak to Lee and Collier in particular, the systems are pretty good for valuations. It's tough to get a reduction, especially on a homestead property, in a residential property in like an association where there's plenty of comps. Once they get all the properties valued, they get trim notices out, they get through the VAB process, then on November 1st, everybody in the state gets their tax bill. On or about November 1st, the last week of October, the government, the appraisers finish their job, and then the tax collector sends out the tax bill. And of course, you get it November 1st, you pay it, you get the discount, monthly discount, and we'll talk about that a little bit in a second. But ultimately, the property taxes are due March 31st, and they're late on April 1st. And you get I said you get the discounts for paying early. Any questions on the tax system basics, on the basics outline of the system? Okay. So let's talk a little bit about this homestead exemption. A person who on January 1 has legal or beneficial title to a piece of property in Florida, makes it as permanent residence, gets an exemption. So, you got to have legal or beneficial title. You can hold title through a trust. It's got to be a revocable trust. It's got to be a real property interest. We'll talk a little bit more on a future slide about that, but basically it's got to be, if you have title in a trust, you've got to present the trust to the property appraiser so they can make sure that it's a real property interest, not a personal property interest. Property held in an LLC or corporation cannot be homesteaded. Once you get the homestead valuation, you get $50,000 off the assessed value of your house, but it's not straight 50,000. It's the first and third $25,000 of value. So what does that mean? If the property is worth $100,000, you get $50,000 off the valuation. You pay tax on $50,000. You get the first $25,000 off of all taxes, all real property ad valorem property taxes that would be your local taxes, your county, your city, and your school board. And then you pay full value on the second $25,000 of taxes. And then on the third $25,000 of taxes, you get all of the same discounts as you did on the first, except for the school board. Why is this important? Well, usually school board is good. In Collier County, it's 50% of your tax bill. So, and in Lee County, I believe it's a little bit less. But you get $25,000 of value off of those portions of the bill. And then in our example, we said the property value was $100,000. You would get, you would pay again the full tax on the fourth $25,000. So it's a little complicated, but it only gets really complicated if the property is worth less than $75,000. Because if it's worth, less than $75,000. If you get, then you start getting a reduced amount of exemption, because you're not the full value to cover all of the first and third 25,000. To qualify, you must be a permanent resident of Florida as of January 1st in the year in which you apply for the exemption. So if you buy your property on December 31st and you move in on the 1st, you can qualify for homestead. But I'm going to put an asterisk next to what I just said, because on the next slide, I'm going to show you where you have to have proof of residency as of January 1st as well. and that can be very difficult. So you can file the homestead exemption as soon as you close on the home. Florida law allows the homestead applications to be filed prior to January 1st of the year you're trying to get the exemption for, but they're only accepted as of March 1st of the year in which you're getting the exemption. So again, another example, you close in November or in October or sometime before the first of the year, and you're like, oh, I want to get this done. So I get my new driver's license, I get my new voter registration, I get my vehicles titled, and then I go apply for homestead. And I'm like, oh, I want homestead for this year. The appraiser is going to say, no, your homestead doesn't start till next year. And that's because as of January 1st of the year after you purchase, you can apply for homestead can be applied to your property. And you only get one homestead exemption per family unit. That's you and your kids. This means that anyone applying for homestead is not entitled to receive the exemption if you or your spouse get a homestead exemption in another state. And they check. The property appraisers talk to property appraisers and the homestead exemption people in other states. Whoever, I'm not sure what they're called in New York, for example, or Pennsylvania, or any of the northern states, but the property appraiser talks to those people and they check to see what you're getting. And if you're trying to double dip, there are penalties. So be very, very careful about that. Any questions on the homestead exemption and when it applies? Yes, JJ.
I was thinking like on an FHA loan, sometimes where the parents have to be on the mortgage and the title, does that affect their homestead at all? Can they still get the full homestead?
So say mom and dad agree to be on the mortgage, and then they get put on the title as well. You could be in a situation where if it's your homestead, but they are homesteaded elsewhere, and they're not part of the family unit, you may get a reduced homestead only on your portion of ownership. So if you own half, you might get a homestead on your half. That is a possibility. I'm not really, what I would say in that situation, if you're going to be homesteading and you're either married or single or whatever, and someone else is going to be on your mortgage to help qualify, be very careful and work with your lender because you have a lot of options. You could put non-homestead language in the mortgage. They may not need to be on the mortgage and the deed, but just sign a guarantee for the funds on the note. So you get a lot of flexibility in that regard.
Okay, great. Thank you for that.
Any other questions on the homestead exemption? Okay. So let's talk about some of the things that you need to get the homestead exemption. You need evidence of ownership. That's your deed. Well, you need the recorded deed in the county where the property is located. You're going to present your social security numbers. You have to be a US citizen to get homestead. If you vote, you'll need your voter registration. It has to be updated prior to January 1st. So earlier, when I gave the example about the closing on December 31st, you may miss homestead for the next year because you've got to have a driver's license, a vehicle registration, and a voter registration dated prior to January 1st to get that homestead. I know that seems very harsh, but it's such a large amount of money to the county to collect these taxes on these non-homestead properties that they're very stingy about it. It can be very difficult. And then, of course, you have the option of declaring your domicile if you file it prior to January 1st with the clerk of courts in your county. Okay, any questions about proof of residency requirements? Yes, JJ?
I'm a pain in the butt. I heard you say they must be American citizens. So what if they have like a permanent visa, but they aren't American citizens? Does that still allow them, or they're out?
You gotta have a social security number or a, I'm not sure if you're a permanent, like a lawful permanent resident, like a green card holder.
Yeah.
I have to check with the appraiser and see if that's a possibility. Let me come back on that one.
Okay, thank you.
make a note about that because that is a great question. I do know that when I was researching the topic, it does say U.S. citizen in a lot of the guidance.
Okay, thank you.
Citizenship versus green card. Okay. Okay, so if you are not, oh, I did look this up. That's funny. I told you it's the first time I did this, JJ, so you just have to bear with me. If you're not a US citizen and you have a green card, they want additional information. So it's not like, hey, you get your homestead, they're gonna ask you additional questions, and I will find out what those additional questions may be. I'll call the appraiser's office. If your property is, how I said this, if your property is held in a trust, you need a complete copy of the trust agreement. And again, they're looking to make sure that the beneficial interest is real property and not personal property. This comes up a lot in land trusts, where you can convert the interest to a personal interest for whatever reason you may want to do that for security's sake. I don't mean like personal physical security. I mean, like if you're going to be selling the property and you want to transfer a personal interest for tax reasons. If it's a mobile home, you need the decals and the registrations of the titles to the mobile homes. If you did have an out-of-state exemption before, you need to get rid of it, and they may check on that. So if it's like your husband and wife, but only one person is on title, they're going to look at that. Okay, any questions on that? So let's talk about Save Our Homes. This is an additional, this is a benefit for property taxes in addition to getting the valuation reduced. Also, there was an amendment passed to the Florida Constitution that limits the amount of tax increase that a homesteaded property can be subject to. It's got to be homesteaded property. It doesn't count for new construction. It goes into effect the year after granting the homestead. And the cap is 3% or the CPI, whichever is less. And when the property is sold to the new owner, the property jumps up to its fair market value. And if the new owner applies for homestead, then they start all over with a new 3% cap based on the value that they paid for the property. So let's dig into that a little bit. Typically, and I'll use Collier County because it's so ridiculous in terms of the valuations, more so than any other county in the state. The properties go up more than 3% a year in Florida. In Collier County, the average is 8%. And if you're homesteaded, then you're limited to 3% or CPI, the Consumer Price Index, which is the inflation index, as the maximum. So if the property is going up 3, and the assessed value is going up 3, and the actual value, the just value, is going up 8, you're saving money every year as you go. The property increases in value, but your property taxes come up less. So it's a very, very valuable thing to get homesteaded over time. And the most extreme example that I found was Mrs. Smith. And just as an aside, I was on city council for 8 years in Naples. And Mrs. Smith was this really sweet old lady who came every year, every council meeting, and talked to us. And she was upset with us about everything that we did. And she was a very nice lady, but she was very critical of city council. And I always used to joke with her because she was in a $10 million house on the beach that had a value of like $150,000 because she had lived in the house for 50 years. So you can see that over time, she's paying a few $100s a year in property taxes on a $10 million house, on really a $10 million lot because the house was a tear down. But she had a significant amount of savings on that property. And there are others similarly situated throughout the state where they just lived there for a long time if you were in 1994 and you had a 3% cap and you haven't sold, well, what has happened to valuations of Florida property in the last 10 years? Certainly more than 3% a year. So this, again, very, very valuable, Save Our Homes. Any questions on this? Okay. So the next part about the tax savings for homesteaders is the fact that it's portable. You don't lose that Save Our Homes exemption when you move. You get to take it with you up to $500,000. So if you're in a $500,000 home and you move into $1 million home, you get to pay taxes on the 500,000 of the new value, and plus the valuation of the old property. I was going to give a bunch of examples on how portability worked and do all the math, but it is so complicated that I'm going to recommend that as a realtor, you not do the portability calculation, and you instead work with your property appraiser in your county to get the portability calculation done based on the proposed sale price and the proposed purchase price of the new property. This complication is double for when you're reducing. So when the kids have moved out and mom and dad are going from the big home to the condo on the beach that they've always wanted, they get to port, it's called porting. They get to port their homestead savings to the condo. But if they're reducing, if the value is going down, then it's a ratio of the current market value and the previous value times the assessed value. So it's even more complicated. I really don't want realtors to go in and do these calculations and then say to their customer, yeah, you're going to save $100,000 when you port your homestead, and then they're wrong. So let's not do that. Let's get with the property appraiser. And if you go to, I know most of you are in Lee County or and elsewhere, but if you go to the collierappraiser.com website and click on portability, there are many examples there, and you can, if you're a math genius, you can try and figure out what some of these examples say, but it is not a straight linear calculation. And this is coming from somebody who has as an 8th grader and is relearning algebra. So I'm not, now I know math, just not portability math.
Yeah, stay in the lane that your license allows you to be in and push everybody over to the experts. I
agree wholeheartedly. And in this case, the expert is going to be your property appraiser.
Yes.
Questions on portability except for math. Okay. So few other exemptions that you can get besides the homestead tax savings. I should say this as additional tax savings. If you are a senior citizen, if you are a disabled veteran, if you are a disabled civilian, a widow or widower, or if you are a not-for-profit organization, there are some tax savings that are available to you. I've listed them in brief on this slide. If someone comes to you and says, I'm a disabled vet, they may pay as little as 0 property taxes on their home. I've had that case. Civilians with a disability, they can get an exemption. And then senior citizens, of course, this is Florida. We protect our seniors. If you are a senior citizen living on less than $31,100, and the county or the city that you're living in has adopted the proper ordinances, then you can get a significant reduction in your property taxes. And of course, not-for-profits don't pay taxes, including property taxes, if they're properly situated and they own the real estate. Okay. So how do you lose homestead? Well, you can lose your homestead if you make mistakes, if you don't follow the law. If you do not have legal or beneficial title as of January 1st, you will not be qualified for homestead. If you purchase the property on January 2nd, You don't get homestead for that year. You have to wait a year, or you have to wait 364 days. When you purchase the property, when you close, say you've closed in March or April or whatever it is, and the seller was a homesteader, but you are not a homesteader, you will pay taxes in the year of the purchase based on homestead. So you will get the seller's reduction. But the next year, you're going to pay the full boat at fair market value because you purchased in the previous year and you're not homestead. So again, you inherit the exemption for the current year, but if you want homestead for the next year, you have to have applied for the homestead after your purchase, but before March 1st. And then if you are no longer qualify, you must self-report to the property appraiser. If you do not self-report, they can go back 10 years. It's a 50% penalty and a 15% interest annually. I see some of you going, wow, that's a lot of money to pay if you try to cheat on your homestead. They're not very forgiving about that. Questions on losing homestead? Nobody has any questions about rentals or anything? Let's talk about rentals anyways. Renting your homestead means you've abandoned your homestead. If you've rented the entire property or substantially all of the property, you have to physically occupy the property. So you can rent a room, you can rent for 30 days in any given calendar year, but I strongly suggest that you not be a rental property on January 1st of each year if you are claiming homestead, because you will lose it. So this is a trick. If you are renting on January, people want to rent for season, they want to rent for Christmas and the holiday, you actually could lose your homestead if your property is rented over New Year's. So don't do that. If you leave the homestead for 30 days to rent it out, you can do that with whenever. If you rent for more than 30 days for 2 consecutive years, then you run the risk of losing homestead because it's not your primary residence. So you got to be very careful there about how you do that. Questions on renting? Okay. If you see me looking off to the one direction, it's because I have 3 screens going across here and I'm trying to look at you guys while I talk to you, and though my slides are on a different screen. All right. So before I go on to the next topic, does everybody understand homestead tax, the basics of homestead tax? Any questions on taxing the property? Okay. Let's talk about restraints on alienation and this is very important for you now. Can you sell your homestead without spousal joinder? That's a very fancy way of saying, does my wife have to sign the deed? Probably. So, one spouse on the title, the buyer buying a second home without the spouse, she has to join in the mortgage. So she should be on the contract. If she's going to be, I'm sorry, let me say, if one spouse is on title, then the other spouse joins the mortgage. If you're selling a second home, then you need non-homestead language in the deed. If you're selling a homestead, then both parties sign, even if one spouse is on title. So say I bought this property 20 years ago and I've lived there happily, and then I go to get married and she wants to get a newer, bigger house. And so we have to go sell the property. And then we go into the title company and they say, Mr. Saad, here, sign your deed. Then they pass the deed over to Mrs. Saad and they say, sign the deed. And she says, but I'm not on title. Well, homestead rights. Spousal joinder is required because you cannot alienate your homestead without your spouse. You can't sell homestead out from under your family. The purpose of homestead is to protect the family, have them a place to live, and not be homeless. That's the purpose of homestead. So you cannot alienate your homestead without your spouse. For if it's not a homestead, if it's a second home, if it's an investment property held by in an individual name, you would put non-homestead language in the property, I mean on the deed. If both spouses are on title, both sign for buying and selling. That's just the way it is. Both buyers, if husband and wife are buying property and it's not going to be their homestead, they still have to sign as the borrower because they could move into the property anytime and make it homestead. If both spouses are on title, all of them sign when you sell. And remember, there are only married and single people in Florida. There are no separations recognized in Florida. So if you've got a couple from New York and one spouse comes down here and says, Renata, are you talking to me? Sorry. Oh, she's talking to somebody else. If one spouse comes down here and says, I'm getting divorced, I don't want my spouse involved. And you ask the question, well, have you gotten completely divorced? And they say, no, we're separated. We have a separation agreement. It's through the courts. Everything's legal in New York. You, unfortunately, spouse has to sign here in Florida. That's just the way it is. JJ is asking, married in another country. If you're legally married in Timbuktu, you are legally married in Florida. So that's the way it is. So the question then comes up, how is it possible to waive that spousal joinder? Well, can one spouse waive their rights? There's a statute. It is unclear at best whether the courts are going to uphold this statute. It's a new statute. I want to say it was effective in 2018. I have not seen a case on it yet. I just looked a couple of weeks ago, and no cases have been reported through my service, which means if there is a case, it's still in litigation, and we won't know the answer to this for some time. But if you do a deed and you put on there, by executing or joining this deed, I intend to waive homestead rights that would be otherwise prevent my spouse from devising homestead property described in this deed to someone other than me, and the spouse signs it, then according to statute, the other spouse could sell the property. The spouse in title could sell the property without the spouse not entitled's signature. But again, I want to be super clear on this, not tested by the courts, new statute, and a lot of lawyers question this. So just be very careful. Okay, any questions on spousal waiver? Okay, I put a few examples. We just got married and she moved into the house. Again, both sign if only he is on title. Again, we just got married and it's the second home that we're selling. He signs as non-homestead, or they both sign the deed. If they're getting divorced, that means they're still married because they're getting divorced. They both sign everything. If they are divorced, then you have to dig in a little further. Did the spouse quit claim the property to the other spouse, or was there a judgment of divorce that specifically and clearly conveyed, awarded the property to one spouse in the divorce decree? Then you may be able to get away with only your client signing and not their spouse. Okay, before I switch to the third and final protection of homestead for homesteaders, does anybody have any questions on spousal joinder? There's no way that you don't have questions. Come on. This is like the most complicated part of
How
homestead.
often do you see people taking their house out of homestead just to be able to sell the home so that their spouse doesn't have to sign off, like during divorces and things like that? Do you guys see people doing that a lot, moving things around before closing?
That's an excellent question. And the answer is you cannot do that.
Okay.
If the spouse always has to, if you have a house, and again, let's go to another example. I have a house in my name, Sam Saad, single man. I get married, and I have a spouse that is, then 6 weeks later we decide it didn't work and we're getting divorced. She has to sign. If I'm trying to sell my house in that 6 weeks because we were going to buy our big beautiful home together, she has to sign because we got married, and even if she never moved into the property, she could move into the property and claim homestead, and then I'm stuck.
My gosh.
So she can't do a quick claim, which is something we've always kind of thought we could do.
Well, again, you could do a quit claim deed with this language in it now.
Okay.
And then maybe I could get away with signing for myself. And the title company would recognize this statute. Anyone who's been paying attention in the last 3 or 4 years understands this and knows this. My point is, the caution I'm giving is it has not been tested by the court system yet. It's a new statute.
So send the customer to their divorce attorney and say, tell us what to do. And then get it in writing so we don't get held responsible for giving legal advice.
Yes. So as a realtor, if you are dealing with a divorcing couple, the first thing that you need to do is have them both sign the listing agreement, whether they want to or not. They both need to sign the listing agreement, and they both will sign the contract, and they both will sign the deed for homestead property. For non-homestead property, and you say you're just talking to the husband, and he signs the listing and he's selling it, ask him, say, is this homestead? Where is your homestead? Oh, we're up in New York. She lives in New York. Then you only need him on the listing, him on the contract, and he will sign a deed with non-homestead language in it. So, but you can't like, oh, we're getting, like, not an example of a divorce, but say she's overseas. This happens all the time. She lives in another country. He's come back here to deal with the Florida property. He's getting it sold and he's going back to Germany, whatever it is. So he's like, my wife can't sign, COVID, we can't get to a notary. It's Germany, it's very difficult. You need a notar, and it's a 6-month appointment and all this other stuff that we deal with German notaries. She has to sign. They're married. There's nothing you can do about it. So we use Ron, remote online notarization now, and we would have her sign electronically through a Virginia notary. It's a remote online notary is a new thing from 2020 that just started. The technology is catching up to the statute, so we're getting better at this.
That does, I know we're talking about homestead, but that just brings up a real quick thing, because we just recently had this where the spouse was in Haiti.
Yeah.
And are there countries that won't allow the?
No. The country that doesn't allow it is the state of Florida.
Okay.
Florida, for example, does not allow remote online notarization for non-U.S. citizens, and it's not a thing against non-U.S. citizens. There's a thing called KBA, knowledge-based authentication, where you have to prove who you are to the remote online notary. You have to correctly answer 4 out of 5 questions from your credit report within 10 minutes. So if you don't have a US credit report where they can pull the questions from, you've probably done this when you've applied for something for credit, and they say, you owned a home at, and they give you 5 addresses.
Right.
Take the one you used to live at, or they say you used to have a roommate, and they've got all those KBA questions, knowledge-based authentication questions. Well, you can't do that if you don't have a US credit report. So that's a requirement under Florida law. It's not a requirement under Virginia law. So we use a service out of Virginia. You've probably heard Notary, it's not a secret, notarycam.com. Maybe you've heard of it. But you can go there, you sign up, and then you tell them you need a Virginia notary, because Virginia will authorize people without KBA. based on just you hold up and you show you show them
Show your ID.
your ID
ID.
on the screen.
Okay.
If you have a foreign passport. So
Good to know.
Florida-
Thank you.
Say it again.
Good to know. Thank you. Thank you.
Yeah, it gets very complicated very quickly. All right. Any other questions on spousal joinder or taxes?
I had a question.
Yes.
I
ma'am.
mean, how is it that it's okay to use a notary from Virginia for something that is being done in Florida with an out of the country client? That it seems something like that we definitely didn't used to do. So is it because of COVID now, and it's valid to use a service from Virginia if we're doing if the paperwork and the property is in Florida?
Yeah, so it's new technology is allowing these things, things like this Zoom call, that didn't used to exist, where we can have a conversation and I can hold up the card that says, here is me, and you can notarize, authenticate them. Virginia, for whatever reason, decided that they didn't want to use KBA authentication, knowledge-based authentication, authentication. So it allows for foreigners to sign based on just on a straight ID. It's actually very scary because there's so much fraud. I mean, we had one guy out of South Africa. He must have called 50, and I'm not even exaggerating, 50 realtors trying to list and sell a vacant lot in Cape Coral. I don't even know, JJ, if anybody from your brokerage got called, but this
We've
guy
got
South
several.
Africa, what?
We had several last week.
Yeah, he's calling and he was trying to pretend his name was Manfred Lorenz. That was who the actual seller was. And then I had a realtor call me up and say, yeah, I actually got a hold of the real Manfred. I'm going to list his property. And I said, I'm not closing it. You find somebody else. I know this property. JD, you're muted. Okay. Yeah, it was really scary, but anybody who gets a call from Manfred Lorenz, that's a fake call. All right, let's move on to asset protection before we get into too many war stories. Oh, wait, I have a question from Mike. If one spouse has a prenuptial agreement, so Mike, even with a prenup, you still need the spouse to sign. As the title company, we can't interpret prenups. We need judges to tell us what to do, or we need spouses to sign. Okay, asset protection. So this is the last Florida constitutional protection for homesteaders. And here's the section of the Constitution. Nice, complicated gobbledygook, legal gobbledygook. And basically what it says is, pay your taxes, pay your mortgage, pay your contractors, pay your HOA dues, and then you can creditors cannot get a hold of your property. The only other time that creditors can get a hold of your property if you've paid all your bills for the property is if you did something really, really, really egregious and you use the money from the crime to purchase the property, then they could take your homestead. But the cases say this is very narrow, and I've only seen one or two of them. So homestead property can be up to 160 acres in the county or half an acre in the city, in any given city. So in the Cape, half an acre, Lee County, 160 acres. And again, if you pay your taxes, pay your mortgage, pay your contractors, and pay your association dues, then it is not virtually impossible, but very, 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 very difficult to lose your homestead in Florida. And this actually is a big thing. You all remember the Enron disaster when Enron collapsed, the energy company out of Houston. All those Enron, that guy, Ken Lay, went to jail, and then I think he died in the jail, but his wife got all the money because they hadn't properly sentenced him yet or some crazy scheme. Well, all those executives from Enron who didn't get arrested moved to Florida, specifically Naples, where they were hiding millions and millions of dollars, because it's not just the property, but all of the personal property in the real property. So if you've got a $10 million house with $50 million worth of artwork in it, you could have $60 million stashed away, protected in your property, in your homestead. So Florida homestead is a very powerful protection. I don't even pretend to know bankruptcy law, but if you declare bankruptcy, you can still have a protected homestead. O.J. Simpson has a Florida, he's not homestead here anymore, he's now in Nevada, but he did have a Florida property where he was protecting all of his things from the parents of the guy that he killed or alleged to have killed.
His son's a realtor in Tampa, St.
His
Pete.
son is a realtor in Tampa. Are you serious?
Yeah.
That's hilarious. All right, the last thing I want to cover, does anybody have any questions about asset protection real quick? Okay, last thing I want to cover with you all today is the federal taxes. So you can save on capital gains when you sell homestead property. Very simple. 2 of the last 5 years, the property must have been your principal residence. They don't say homestead in the federal tax code, they say principal residence. Individuals get $250,000 of gain tax-free, and married couples get $500,000. Any questions on that? Any questions overall? None? Come on. Oh wait, okay. I got one from the in the chat here. I have a buyer of a new construction loan to perm, which closed in June of 2021. We're hoping the house will be finished by December. However, if it isn't, could the owner apply for homestead before January of 22 and before the CO is issued? The house is in Cape Coral. So the answer is probably not. And this says iPhone sent this to me, so I don't know who actually sent it to me. Probably not. And here's why. You have to make it your permanent residence. You have to live in the property. So if the property is not completed and you can't move in until you get at least your temporary CO, you can't make it your homestead. So what this person will probably do, if the house is finished in December, no problem, move in, apply for homestead by March 1st of 2022, and you get your homestead for the year 2022. If it's not completed till January or February of 2022, you would move in, you would apply for homestead once you've moved in, and you would get homestead for 2023, and it will be based on the fair market value of the fully built home.
That brings up the question. So like if the home is finished halfway through 2021, right, the taxes are based just on land value.
For 2021.
For 2021. Is there any, they used to take their time before they catch it up. But right now, am I correct that in 2022, they're going to catch that value of the house immediately? There's no there's no window of opportunity other than their 6 months in 2021.
Right, not anymore.
Okay, I just want to make that really clear because it used to be we could play a little game and we'd almost buy another year, but not
That's
anymore.
the old days. Now we got the internet, everything's faster. Okay, other questions about the presentation? Anything about homestead? Nothing? Any other questions about anything that you're working on in your office that seems odd or strange you need help with? JJ's like, yes, there's a lot, come over.
No, I think we learned some
every day.
We learned some good stuff today. And I love that fact about talking about the renting of the rooms, because that the B&B, the Airbnbs seem to be a huge issue with even the counties and the cities zoning. They're paying particular attention now to what our customers are doing with their properties when because they're advertising. You know, it's out there that we're renting. They got to be really
the game
careful.
I'm seeing is people will put up generic house pictures on their Airbnb. They'll put up pictures of the neighborhood, but not the actual house, because they're worried about getting busted by the taxing authorities for not paying sales tax on short-term rentals. That's the big one, and losing their homestead. So yeah, you got to be super careful if you're doing Airbnb. If I can go back here real fast. So if you rent the property for less than 30 days per calendar year, no problem. If you rent a portion of the property for more than 30 days per calendar year for 2 consecutive years, you're going to lose all or a portion of your homestead.
Can they go back and they can go back and fine you, make you,
10
make you,
years.
yeah, that's what I thought. Okay, because we want to remind them of that kind of stuff. So here's a weird question. Do you know how many states have homestead? There are some states that don't have homestead laws. Am I correct?
Whoops. There are many states that don't have homestead laws. I don't know all of them. I've not done a comprehensive review of all the states. I think New York State, you get like $25,000, some ridiculously small amount. It's like a month's living expenses in New York City. Not even. But in Florida, it's one of the most expansive. Florida, South Dakota have the top asset protection laws. I mean, South Dakota blows everybody away, but Florida is right up there in terms of asset protection, what you can protect.
And that's a great reason that we're the largest, third largest growing, fastest growing state in the United States.
Are we the fastest growing now?
I think we were either like number 2 or number 1. Yeah, so we're beating California on a lot of stuff now. We actually now have more realtors in Florida than we do in California, if you can believe it.
Yep, certainly got more lawyers. Jesus.
Yeah, whatever you bump into a lawyer or a realtor. So
any other questions for me on other topics?
If there's a topic you want Sam to do, either put it in the chat or let Joanna, myself know, and then we can pass it on to Sam and he can put together a really super presentation for him. All right, y'all have a fantastic afternoon. We're right on time at 10:54. And if you have any questions, again, use Sam, call him, use his Paradise Post title. All right, have a great one. Bye.
Bye-bye.